Welcome all, my dear friends. Let us continue our journey in the world of patents. Today's key term is compulsory licenses. Okay, friends, till now we have discussed up to form number 16 and its relevant sections and rules. Okay, so now it's the turn for form number 17. Okay, and the key term for form number 17 and its relevant sections and rules is compulsory licenses. Fine. So compulsory licenses, or what is so here we will try to analyze what is compulsory licensing in a literal way and how it is significant in the world of patents. Okay. Okay, so next, in the next slide we will try to analyze the literal meaning and the meaning in the patent world. Fine, let us proceed. Friends, as we know that the key term for form number 17 is compulsory licenses, so you can see here that compulsory license indicates form number 17. Fine. So now we will see what does it mean literal. Okay. So compulsory means that must be done, plus license, compulsory license. Okay, so what is the meaning of license? License is an official permission to do, use or own something. Now this is the literal meaning of compulsory license or compulsory licensing. Now we will see how compulsory license is defined in case of, or we can say in the world of patents. Okay, so let us see. A compulsory license is an official permission by the government allowing someone else to produce the patented product or process without the consent of the patent owner. Fine. So you can very easily differentiate between the literal meaning of the compulsory licensing and the meaning in the world of patents. Fine. Then form number 17. The title is Application for Compulsory License. Okay. Here the related sections are 84, 91, 92, 92A. And the related rule is only one, that is rule number 96. So we will discuss briefly about all the sections. Section 84 is compulsory licenses. Section 91 is licensing of related patents. Section 92, special provision for compulsory licenses on notification by central government. Section 92A, compulsory license for export of patented pharmaceutical products in certain exceptional circumstances. Fine. And rule number 96 says application for compulsory license, etc. So here the keyword is no need to explain. The keyword here is compulsory license. Fine. Next we'll proceed to form number. After refreshing our memory from the old slide, and as we have seen the established relations between the relevant sections, rules and form number 17. Now let us proceed to the particular section number that we will discuss today. And the particular section number is section 84. And this comes from chapter 16, whose title is Working of Patents, Compulsory Licenses and Revocation. Fine. And section 84 has the title Compulsory Licenses. Section 84 has the title Compulsory Licenses. Just remember it and we will discuss in detail in the next slides. Fine. Okay. Now let us try to understand the subsections of section 84 through the keywords or the key terms. Okay. So the key term or the key phrase for subsection 1 is grant of compulsory license. The keyword for subsection 2 is stopped. The keyword for subsection 3 is statement. The key term or the key phrase for subsection 4 is grant a license. For 5, for subsection 5, it is exercise the powers. For subsection 6, the key term or the key phrase is the application field. And for subsection 7, the key phrase is reasonable requirements of the public. Okay. So friends, please try to remember this keywords or the key terms or the key phrases and try to recall the subsections of section 84. Okay. I have chosen the keywords, or I have picked up the keywords as for my intellect, my convenience. You can choose your own. Okay, fine. Okay. After picking up the keywords, let us go for the details of the subsections. Fine. Subsection 1. This says, at any time after the expiration of 3 years from the date of the grant of a patent, any person interested may make an application to the controller for grant of compulsory license on patent on any of the following grounds, namely, Clause A, that the reasonable requirements of the public with respect to the patented invention have not been satisfied, or Clause B, that the patented invention is not available to the public at a reasonably affordable price, or Clause C, that the patented invention is not worked in the territory of India. Okay, so friends, first of all, let me show you the single star mark indicates substituted by Act 15 of 2005, Section 52 for sealing with effective from 1st January 2005. So earlier the word was sealing and now the word is grant inside the square brackets after the amendment. Fine. So now let me analyze the whole subsection. Okay, here the key term or the key phrase is grant of compulsory license. Fine. And you can see the words in blue background. This shows after the expiration of 3 years. That means this is the time period. Okay, and inside the clauses you can see in clause A, you can see the ground is reasonable requirements, okay, not been satisfied. And for clause B you can see not available to the public at a reasonably affordable price. And in clause C you can see not worked in the territory, and that is territory of India. Okay, so we can analyze this whole subsection in very simple words. Let me explain, just listen carefully. Fine. Okay, grant, there is a grant of patent date. Fine. And after 3 years, what happens? Any person interested applies to the controller for what? For compulsory license on the patent. But how can he apply for this? That means he must have some grounds. So what are the grounds? So ground number 1 is reasonable requirements of the public with respect to the patent has not been satisfied. Fine. Or second point, or the second ground, we can say the patentable invention is not available to the public at an affordable price. Fine. Or point number 3, or clause C, the patented invention is not worked in the Indian territory. That means we can say either of the 3 clauses is sufficiently a ground. That means it can be a ground for a person interested to apply for a compulsory license to the controller. Okay, that means any person interested can make an application for grant of compulsory license on the patent based on the following grounds, and either condition is fine to the controller. And the next steps we can find what the controller does. Okay, fine. So I hope now subsection 1 is pretty much clear. Fine. So we will go to the next steps. Fine. Subsection 2. This says, an application under this section may be made by any person, notwithstanding that he is already the holder of a license under the patent, and no person shall be stopped from alleging that the reasonable requirements of the public with respect to the patented invention are not satisfied, or that the patented invention is not worked in the territory of India, or that the patented invention is not available to the public at a reasonably affordable price by reason of any admission made by him, whether in such a license or otherwise, or by reason of his having accepted such a license. Okay, so here the keyword is stopped. And what does it mean? Stop, we can say, in law, actually, this is the, we can say, stopped is a verb form. If we go to its noun form, it means estoppel. Estoppel is the noun form. Estoppel is a legal doctrine that holds that a party can be stopped from doing something that is inconsistent with their previous actions. So here, stopped means just stopping someone. Fine. So here, friends, we can say, while we were discussing about subsection 1, you must have noticed the thing that there we discussed any person interested. Okay, and here only any person. So this is the differentiation between these two subsections, that for subsection 1 the person was any person interested, and here any person. Fine, got the difference? Now I will analyze the whole subsection. Just listen carefully. Okay, a license under the patent can be any, no, we can say like this. Just I'm telling it again. Try to listen carefully. Okay, a licensee. Okay, a licensee under the patent can be any person who can apply to the controller for a compulsory license. Got it? A person who is a part of a license or involved in any way with it can also apply to the controller for a compulsory license by showing the below grounds. So what are the grounds? Ground number 1, reasonable requirements of the public has not been satisfied, or ground number 2, the invention not available to the public at affordable price, or ground number 3, the invention is not worked in Indian territory. That's all, friends. This is the essence of subsection 2. I hope it is pretty clear now. Okay. Subsection 3 says every application under subsection 1 shall contain a statement setting out the nature of the applicant's interest together with such particulars as may be prescribed and the facts upon which the application is based. Okay, so here the keyword is statement. Fine. So in a very simple sentence, I would like to analyze this subsection. Okay, just listen carefully. An application under section 84 subsection 1 shall contain a statement about the nature of the applicant's interest with particulars and the facts on which the application is based. This is the simple meaning of this subsection. I hope it is clear now. So let us proceed. Subsection 4 says, the controller, if satisfied that the reasonable requirements of the public with respect to the patented invention have not been satisfied, or that the patented invention is not worked in the territory of India, or that the patented invention is not available to the public at a reasonably affordable price, may grant a license upon such terms as he may deem fit. Okay, and here the key term or the key word is grant a license. Okay, so we can say, that means in brief, I can analyze the subsection. Just listen carefully. Okay, the controller may grant a license upon the below grounds if he or she is satisfied. Okay, what are the grounds? Ground number 1, reasonable requirements of public is not satisfied, or ground number 2, the invention is not worked in Indian territory, or ground number 3, the invention is not available to the public at affordable price. Now this is the whole essence of this subsection. I hope it is pretty clear now. Fine. Okay, let us proceed then. Subsection 5. This says, where the controller directs a patentee to grant a license, he may, as incidental thereto, exercise the powers set out in section 88. Okay, here the key term, the keyword or the key phrase is exercise the powers. Okay, and as section 88 is mentioned here, the title of section 88 is powers of controller in granting compulsory licenses. Fine. Okay, so let me analyze the subsection in a very simple words. Okay, so just listen carefully. When the controller directs the patentee to grant a license, he can also exercise his powers conferred to him by section 88. And this is the simple essence of subsection 5. So I hope it is clear now. So let us proceed to the next subsection. Subsection 6 says, in considering the application field under this section, the controller shall take into account, clause 1, the nature of the invention, the time which has elapsed since the sealing of the patent, and the measures already taken by the patentee or any licensee to make full use of the invention. Clause number 2, the ability of the applicant to work the invention to the public advantage. Clause number 3, the capacity of the applicant to undertake the risk in providing capital and working the invention if the application were granted. Fine. So here the key term or the key phrase is the application field. Okay. So in a very simple way, I can analyze this subsection. So please listen carefully. Okay. The controller shall consider the below points for application field for the application field. Okay, as per this section, that is section 84. Okay, so point number 1 is nature, time and measures taken by the patentee or the licensee to make full use of the invention. Okay, point number 2, the ability or the capability. Okay, the ability of the applicant to work the invention for public merit. Okay, that means the second point is ability of the applicant to work the invention for public merit. Fine. Point number 3, the capability of the applicant in terms of capital and working. Okay, the capability of the applicant to take the risk in terms of capital and working. Okay, if the application were granted. So we can say here in subsection 6, some points are there, okay, and they all should be taken into account while considering the application field under section 84. Fine. So the words written in blue are the main key points, you can say, so that you can very well grasp the essence of this subsection. Okay, and actually subsection 6 is not finished now. It has another point actually that we will discuss in the next slide. Okay. Okay, so point number 4 or clause 4 says as to whether the applicant has made efforts to obtain a license from the patentee on reasonable terms and conditions, and such efforts have not been successful within a reasonable period as the controller made him fit, provided that this clause shall not be applicable in case of national emergency or other circumstances of extreme urgency, or in case of public non-commercial use, or on establishment of a ground of anti-competitive practices adopted by the patentee, but shall not be required to take into account matters subsequent to the making of the application. Explanation is, for the purposes of clause 4, reasonable period shall be construed as a period not ordinarily exceeding a period of 6 months. Okay, and the single star mark indicates that the whole explanation that is inside the square brackets is inserted by Act 15 of 2005, Section 52, with effective from 1st January 2005. Okay, so point 4 or the clause number 4 can be explained like, just listen carefully. The the reasonable period is fixed to 6 months so as to eliminate the possibility of dragging the voluntary negotiations by the patentee. Okay, this clause is not considered by the controller in case of national emergency, extreme urgency, public non-commercial use, or on establishment of a ground of competitive practices adopted by the patentee, etc., etc. Well, friends, so this is the simple explanation of subsection 6. Fine. So I hope it is pretty much clear now. We can proceed to the next subsection. Subsection 7. This says, for the purposes of this chapter, the reasonable requirements of the public shall be deemed not to have been satisfied. Clause A. If by reason of the refusal of the patentee to grant a license or licenses on reasonable terms, subclause 1, an existing trade or industry or the development thereof or the establishment of any new trade or industry in India or the trade or industry of any person or class of persons trading or manufacturing in India is prejudiced, or subclause 2, the demand for the patented article has not been met to an adequate extent or on reasonable terms, or subclause 3, a market for export of the patented article manufactured in India is not being supplied or developed, or subclause 4, the establishment or development of commercial activities in India is prejudiced, or. So here friends, you can see the key term or the key phrase is reasonable requirements of the public. Fine. And the key term of the clause A is by reason of the refusal of the patentee to grant a license or licenses, we can say. That means by reason of the refusal of the patentee. This is the key term. Fine. So, and it has so many subclauses. Okay. So, we can say as a whole, this subsection provides various circumstances which the controller shall consider to find out if the reasonable requirements of the public have been met. Okay. The reasonable requirements of the public shall not be deemed to have been met in following conditions. Okay. Then those conditions are defined in terms of clauses and subclauses. So, just listen carefully. So, clause A says, if patentee refuses to grant a license or licenses as a result of which, subclause 1, existing trade or industry or development is prejudiced, in short I am telling, okay, or subclause 2, if the patented article is not available to public on reasonable terms, or subclause 3, if the establishment or development of commercial activities in India are prejudiced, or subclause 4, if the patented article manufactured for export has not been supplied. Okay. Actually, friends, I made a mistake here. Okay. I just swapped between subclause 3 and subclause 4. So, I will repeat them again. Okay. Up to subclause 2, everything is fine. From subclause 3, I would tell you. Fine. So, subclause 3 says, if the patented article manufactured for export has not been supplied, or subclause 4 is if the establishment or development of commercial activities in India are prejudiced. Now this is fine. Okay. So let us proceed for the next clause, because subsection 7 is a lengthy subsection. So I have divided or classified it into different parts. Okay. So clause A is completed now. We will go for the subclause. Sorry, we will go for the clause B in the next slide. Fine. Subsection 7 is continued and we will continue from clause B. Fine. Okay. If by reason of conditions imposed by the patentee upon the grant of licenses under the patent or upon the purchase, hire or use of the patented article or process, the manufacture, use or sale of materials not protected by the patent or the establishment or development of any trade or industry in India is prejudiced. Or clause C. If the patentee imposes a condition upon the grant of licenses under the patent to provide exclusive grant back, prevention to challenges to the validity of patent or coercive package licensing, or clause D. If the patented invention is not being worked in the territory of India on a commercial scale to an adequate extent or is not being so worked to the fullest extent that is reasonably practicable or. Okay, so let us analyze first clause B. Fine. So simply we can say that clause B says, by reason of conditions imposed by the patentee upon the grant of a license under the patent, the hire, use, sell or manufacture of the articles not protected by patent or the establishment or development of any trade or industry in India is prejudiced. Fine. So next we will go to clause C. Okay. And the operator here is or, that means B or C. Fine. So clause C says, or I can say in a very simple way, just listen carefully. Clause C. The licensor bears an exclusive right to use or sublicense any patented improvements, whereas the licensee retains only a non-exclusive right to practice the patented improvement. Okay, and this provision is called exclusive grant back. I think I shall repeat it. Okay, just listen. The licensor bears an exclusive right to use or sublicense any patented improvements, whereas the licensee retains only a non-exclusive right to practice the patented improvement. And this provision is known as exclusive grant back because the key term of this clause is exclusive grant back. So that I have defined here. Also friends, there is another key term here. You can see this is coercive package licensing. This is also a new term. Okay. So let me define this as well. Okay. So what is coercive package licensing? Just listen carefully. Fine. When patent owner licenses a patent, again telling, I am discussing about or I am trying to explain coercive package licensing. Just listen. Okay. When patent owner licenses a patent, there may be requirement of licensing more than one patent in order to commercialize the invention. Fine. Such license for the multiple patents is called as package license. Fine. Here the license shall choose each of the patents it wishes to license. This is absolutely legal. Fine. If the licensor forces the licensee to take license for patent or patents, even if it is not required by licensee, okay, such license is called as coercive package license. That means in a way the licensor forces the licensee to take license of the patents. Okay, this is known as coercive package licensing. I hope it is pretty clear now. Fine. Next I will go to clause D. So clause D as a whole says, if the patented, just listen now, if the patented article is not worked in India on a commercial scale to the fullest extent possible, or I can that means the essence of this clause is, if the patented article is not worked in India on a commercial scale to the fullest extent possible, on the fullest extent possible, or that is reasonably practicable. Okay, then or operator is then, other clauses are there that I will discuss later. So here for this particular, for this specific clause, I can give you an example. Just listen. In Camborian's patent, the patentee shall not be able to defend on the ground that the invention was once worked and then discontinued. Fine. So this is just an example. You can search for it. Okay, just a second, friends. So I hope this clause is also clear now. So I will proceed for the next one. Okay. So now clause E. This says, if the working of the patented invention in the territory of India on a commercial scale is being prevented or hindered by the importation from abroad of the patented article by subclause 1, the patentee or persons claiming under him, or um, subclause 2, persons directly or indirectly purchasing from him, or subclause 3, other persons against whom the patent is not taking or has not taken proceedings for infringement. Fine. So, just a second. So, clause E can be explained as, just try to grasp it. Okay. So, clause E says, it shall be deemed that the reasonable requirements of the public have not been met if the patentee, instead of working the invention in India on a commercial scale, is importing the patented product from abroad. Fine. Hence, the applicant may invoke the ground that the reasonable requirements of the public have not been met due to the importation of the product from abroad. Fine. This may happen in those cases wherein the product patent belongs to foreign MNCs having no manufacturing base in India. Okay, this is the simple explanation of clause E. I can read it again for you. If the working of the patented invention in the territory of India on a commercial scale is being prevented or hindered, that means the working is hindered here. Why? By the importation from abroad of the patented article. Okay. So, by how? What are the means? By the patentee or persons claiming under him, or persons directly or indirectly purchasing from him, or other persons against whom the patent is not taking or has not taken proceedings for infringement. Okay. So, we can say, friends, this way subsection 7 is also, I hope it is pretty much clear now. So please go through all the subsections and try to grasp the essence of these subsections. And I must say, friends, section 84 is a very important section, and whenever Section 84 is uttered, just remember it is compulsory license. Okay, you have to set this in your mind. Fine. The related case law for Section 84 of the Patents Act 1970 is Natco Pharma Limited versus Bayer Corporation. Okay, but as I have already said that the case laws I will discuss in separate video lectures. Okay, to have a very uh, clear impact uh, on your preparation. Fine. Okay. So we have heard about the terms like voluntary license, compulsory license. Okay, So let me just compare between the two. Okay. So what is voluntary license? Voluntary license is an official paper that shows you are allowed to do or have something, or you have the permission to enter or use the property of another. Right? This is a simple. That means license means, in normal terms, whenever you utter the term license, it is voluntary license. Fine. And then what is compulsory license? Compulsory license, it is a legal document by which a bank, building, society, etc. lends money at interest in exchange for taking title of the debtor's property, with the condition that the conveyance of title becomes void upon the payment of the debt. Fine. So I hope now you can differentiate between these two. Fine. The reference is Patents Act 1970 as amended by Amendment Act 2005 and the Patents Rules 2003 as amended by Amendment Rules 2021. So friends, please like, share and subscribe the channel. Thank you all for listening to me and thank you all for watching my video. Stay safe, stay blessed. God bless you. Jai Hind.